versus Chris Daniel Aguilar. This is the time set for an initial appearance hearing. Would the state please announce?
Michelle Morgan, on behalf of the state, I'd like to note for the court that the victim's next of kin, as well as extended family, is present in the courtroom along with our victim advocate, Karen Manning.
All right. Ms. Manning, do you want to go ahead and announce?
Yes, Your Honor. Victim advocate Karen Manning, and we have the next of kin.
Thank you.
Do you want her to say her name?
Sure.
Graciela.
All right, thank you. Is probation on the line for this case? No. All right, Ms. Colson.
Good afternoon, Sheriff Colson, the Office of Public Advocate, asking you to appoint for the IA only for Chris Aguilar.
All right, I'm going to appoint you for the IA only. And then, Chris, your full name and date of birth, please.
Chris Aguilar, October 31st, 2008.
All right, thank you. I'm going to go ahead and read the victim advisory. If you're the victim of a crime in a case pending before this court, you're advised that you have rights to justice and due process under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial and a prompt and final conclusion of the case, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing your loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. All right, Chris, I am going to let you know your constitutional rights. You have the right to remain silent. Anything you say to anyone other than your lawyer could be used against you. You have the right to a lawyer, even if you can't afford one. And I'm finding that you're indigent, so I'm appointing the Public Defender's Office to represent you after today's hearing. And Ms. Colson, do you need me to read the charges to him?
No, Your Honor, we would waive that.
Okay. All right, then we'll show that he's waiving a reading, and I'm entering a not guilty plea on his behalf. And then we need to discuss release conditions. What is the state's recommendation?
Thank you, Your Honor. If I may check to see if the next of kin would like to address the court first.
Yes.
I think she asked her support person to speak on her behalf.
The family is requesting no bond.
Okay, thank you.
Thank you, Your Honor. The state is aware that this is not a type of situation where the juvenile can be held non-bondable. But we do believe that a high bond is appropriate in this case. The pertinent 13-3967 factors are the victim's views. Obviously, they do not want the defendant released in any manner. That's why they said no bond. The nature and circumstances of the offense charged, the danger the defendant poses to the community. My understanding is that this offense occurred in a school classroom where other students were present. My understanding from the police report is the defendant allegedly first punched the victim after choosing to sit next to him in the classroom where he normally did not sit multiple times, and then proceeded to stab him more than once with a knife that he had on his person. According to the police report, the defendant was the aggressor in the classroom, and the victim had no ability to defend himself. The victim subsequently died of his wounds. These are very serious allegations. Someone lost their life in a school classroom where he should have been safe. Given the nature and circumstances of the offense, we are asking that a bond in the amount of $1 million cash be imposed. We do not believe he can be released safely in the community, but we do understand that this is the type of case where a bond must, that it cannot be held non-bondable. If he's released in any manner whatsoever, We ask that it be to pretrial services with electronic monitoring, no contact with the victim, the scene, or anybody else involved. With regards to if he's detained, the JJDP report is recommending that he be housed in the custody of the Maricopa County Sheriff's Department, and we are in agreement with that assessment. A couple of the factors that they outlined, which are to be considered by the court, is the nature and circumstances of the offense and the safety of the other detained juveniles. Again, I will highlight that the allegations are that he assaulted and then subsequently took the life of one of his classmates at school. So we have very serious concerns about the safety of other juveniles that are detained in juvenile detention, and we agree with probation's assessment that he be housed in the custody of MCSO. Thank you, Your Honor.
Thank you. Ms. Colson, on behalf of your client.
Thank you, Judge. And regarding the bond, we would ask for a security appearance bond. We do not believe $1 million cash is appropriate. Typically for first-degree murder charges, we see $1 million. We typically do not see that for second-degree murder, which is what the current charge is. So I do not believe $1 million is appropriate. We would ask for a lower bond, and we'd ask for a security appearance bond. In regards to both the bond and whether or not he's going to be housed at Durango or at Lower Buckeye Jail, we would ask for him to stay here at Durango for several reasons. Chris is only 16 years old. He has no criminal history. This is his first and only offense. He's not been in trouble before. He also has a lot of family support. You can see them here today in the court. Even though they're nervous, they're still here, and they're here to support Chris. He's lived in Arizona almost his entire life. He's not a flight risk, so we would ask for him to be housed at Durango. I know he's only been here for a very short time. However, he's in a blue shirt, and there's been no incident.
All right, thank you. All right. Chris, did you want to address the court just about release? No. All right. Okay, at this time, given all the information in front of the court, I know that the victim's family was hoping for no bond. This is a case where legally the court can't hold Mr. Aguilar without a bond. At this time, the court is ordering a cash-only appearance bond in the amount of $500,000. If he were able to post that bond, then you would be on pretrial services. You would do alcohol testing and monitoring, drug testing and monitoring. You would be on house arrest on an ankle monitor. You would not be able to return to the scene of the crime. No contact with the family. And no contact with the arresting officers. You would not be able to access the internet except for school. Not to possess any weapons, not to possess any drugs without a valid prescription, not to possess or consume any alcohol, not to drive a motor vehicle without a valid driver's license. Given the recommendation of probation, I am ordering that you be, and I've considered the factors contained in the Federal Juvenile Justice Delinquency and Prevention Act, I am ordering that you be placed into the physical custody of the Maricopa County Sheriff's Office jail until released. And just so everybody knows, orders can be modified. I know the jail themselves evaluate where he should be placed every 30 days, so it could be that you would be moved back to detention. So your next court date, the next court date will be August 26th at 8:30 for a status conference, and then the preliminary hearing will be on August 28th at 8:30. Those will all be in the South Court Tower in downtown Phoenix. And then we will be getting your signature over here on the release order. Is there anything else from the state?
Nothing from the state, Your Honor.
Anything else from you, Ms. Colson?
No, Your Honor, thank you.
All right, thank you, everybody. Court is adjourned.